Hello, my dear friends. I'm Dr. Waseem I Khan, Assistant Professor, Sri Shivaji Law College, Parbhani, Maharashtra, India. In today's lecture, we will discuss a last part of tort of nuisance, that is, remedies available for the tort of nuisance. So, let's start the topic. Remedies for nuisance. This introduction we have already discussed in the previous three lectures. We have discussed the three part of the nuisance in the earlier lecture. The first one is essentials of nuisance, second one is types of nuisance, and the third one is defenses available for the tort of nuisance. In this lecture we will discuss the remedies, and before discussing the remedies I will try to explain certain introduction. If due to the act of any person, other person is feeling discomfort, then it is a perfect example of nuisance. If I am doing any act due to which if you are feeling discomfort, I will be held liable for the tort of nuisance. If due to the act of mine, if you are getting annoyed, if any kind of injury caused to you, so I may be held responsible for the tort of nuisance. And in nuisance, the interference must be unreasonable, unlawful, and the interference must be indirect. If the interference is direct, it will be a trespass, not the nuisance. So the interference must be indirect, the interference must be unreasonable, the interference must be unlawful, then only I will be held responsible for the tort of nuisance, otherwise not. So this is the particular introduction of nuisance. Now we will move towards the remedies available for the tort of nuisance. The first remedy, which is extrajudicial remedy. The remedy which is available out of the court is supposed to be known as an extrajudicial remedy, and abatement is an extrajudicial remedy available for the tort of nuisance. So abatement means the removal of nuisance by the party injured. Suppose if my neighbor is creating a nuisance, I can remove that particular nuisance, and this is called abatement. And for removing the nuisance, there is no need to file a suit before the court of law. So my neighbor is creating a nuisance. If I remove that nuisance, then it's okay. That is a remedy available for me. Now there is no nuisance and there is no discomfort to me. So I can remove the nuisance without filing a suit before the court of law, because this is a remedy. Abatement is a remedy available for the tort of nuisance. The removal must be peaceable, without danger to life or limb. So whenever I want to remove the nuisance which caused by my neighbor, that removal of nuisance must be peaceable. It should not cause any kind of danger to the life of my neighbor and to the limb of my neighbor. So if I want to remove the nuisance, I must remove that particular nuisance in a peaceful manner. I cannot injure my neighbor while removing the nuisance. So abatement is a remedy, extrajudicial remedy available for the tort of nuisance. In case of abatement, if it is to be interred on another's land or property, prior notice should be given to such person. Suppose if I want to remove the nuisance, and for the purpose of removing the nuisance, I have to enter into the premises of my neighbor. Then before getting the entry, prior notice should be given to my neighbor. If without giving a prior notice, if I enter to the premises of my neighbor, I may be held responsible for the tort of trespass to land. So if the entry is required for abating the nuisance, permission must be taken from the person who is creating the nuisance. So abatement is the first remedy available for the tort of nuisance. Abatement means a removal of nuisance. So out of the court, the plaintiff can remove the nuisance and he can avail this kind of remedy, extrajudicial remedy. Now the second remedy available for the tort of nuisance, which is a judicial remedy, that is damages. The damages in case of nuisance are based either on the actual loss or damage to the property. So damages or compensation is one of the common remedy available for the any tort, and even for the tort of nuisance. So I can claim damages if due to the act of my neighbor, if I am feeling discomfort, if I am getting annoyed, I can file a suit before the court of law and I can claim damages. I can claim a loss, and for that particular purpose I have to prove the loss. So if there is a damage to the property due to the act of my neighbor, I can file a suit against him and I will be entitled to get a compensation. So damages is a second judicial remedy available for the tort of nuisance. This is the most common remedy available for any tort. The third remedy available for the nuisance is injunction. In order to obtain an injunction, the plaintiff has to show that the injury caused to him by the defendant must be present and not future. So injunction order can be passed by the court, in which the court can order the creator of nuisance not to do that particular act in future. The court can restrain the person from doing the act in future by passing the order. It can also be said as a stay order. So for availing the injunction, the injury must be present. The injury caused to the plaintiff by the defendant must be present and not future. I cannot claim an injunction by merely saying that due to the act of neighbor there will be a nuisance and there will be injury to me. This will be the future injury. If the future injury is there, injunction order cannot be passed by the court. For passing the order of injunction, the injury must be present, then only injunction order will be passed, otherwise not. Suppose if my neighbor is using a heavy machineries due to which there is a discomfort, if I filed a suit against the defendant, I can claim the injunction and court will pass the order, stop your work immediately. So that is the injunction. So I hope you understand this topic, or if you understand this topic, please like the video and share this video with your friends. Thank you very much.